Child support is based on the policy that both parents are expected to financially support their children, even if they are not living with both parents. Either a parent or a person who has physical custody of the child may apply for child support services at their local child support division. The parent who does not have custody of the child can be ordered to pay child and medical support. Issues such as custody and visitation must be resolved in court if they are to be legally enforced. In determining how much child support to order, the court will consider both parents' incomes, who the child lives with, expenses paid by either parent for child care, health insurance, dental insurance, and child support for other children. The court will then use the child support worksheet and child support guidelines to decide how much child support to order. If the court believes the parent could be working but chooses not to, the court can impute income to that parent. This means that for the purposes of the child support worksheet, the court will act as if the parent is working and will put an income for that parent on the worksheet. The court will usually impute at least minimum wage full-time employment. However, if a parent has worked in the past and made more money than that, the court can impute a higher amount of income. If one parent is caring for a child of the parties who is age 3 or younger and is not working, the court will not impute income to that parent. Paternity means fatherhood, and once established, a legal duty to support a child is created. Even if the parents are unmarried or have never been married, they are both responsible for supporting their child until they become an adult. Paternity can be established voluntarily by both parents, or it may be established by the court. Paternity should be established when the child is born to an unmarried woman, when the child is born to a married woman and fathered by a man other than her husband, when there is more than one possible father, and before the child is 18. When the parents are unmarried, they can sign and have notarized the Voluntary Acknowledgement of Paternity form. Once the form is signed and notarized by both parents, a father and child relationship is legally created. In addition to this, the acknowledged father's name will appear on the child's birth certificate as father. This signed form has the same effect as a paternity judgment entered by the court. The voluntary acknowledgement form is voluntary. Do not sign this form if you are not the biological father of the child's mother is married to another man and he does not sign the form, you want genetic tests to determine if you are the biological father, you are the mother and want genetic tests to determine the child's paternity, or you are a minor. The voluntary acknowledgement can be voided or taken back within 60 days. The court may also void the acknowledgement. The court must resolve the issues of paternity if the unmarried parents are under 18, the mother was married to someone other than the child's father, and the husband does not sign the voluntary acknowledgement of paternity, or if there is more than one possible father. Kentucky law requires that child support payments be deducted from the non-custodial parent's paycheck and paid through a state disbursement unit. Federal and state law allows the child support program to use enforcement methods which include, but are not limited to, the following: file liens against real and personal property, seize bank accounts, savings, bonuses, and lump sum earnings, intercept state and federal income tax refunds, take a portion of unemployment compensation or workers' benefits, deny, suspend, or revoke a driver's license and other operating licenses, deny, revoke, or limit passports, or file criminal actions against the parent. Child support enforcement services are automatically provided to current and former recipients of KTAP and public medical assistance. Your KTAP caseworker will refer your case to the appropriate child support office. Child support payments collected for families receiving public assistance go to the state and federal government as repayment for public assistance. If your family is not receiving KTAP or medical assistance, you can apply for Child Support Enforcement Services by completing an application for services. If a court ordered you to pay child support, or if you are getting child support for your child, you can ask the court to change the amount of child support in the order. To do this, you must first go to the court that ordered child support in the first place. The court will use the child support guidelines to determine if the current child support obligation should be decreased or increased. If the review shows a material change in circumstances, that is, a 15% increase or decrease in the amount of support due, then the child support order will be adjusted. A continuing change in circumstances may occur if a parent loses a job, a parent gets a new job and makes more or less money than he or she did before, there is a change in custody of the child becomes disabled or needs a lot of medical care. If you and the other parent have just moved to Kentucky and the original order is from out of state, you can register the other state's child support order with the Kentucky court in your county. After you register the out-of-state order, you can ask the Kentucky court to change the order. Your local county child support division can help you with registering, changing, or enforcing an out-of-state order. If any of these situations apply to you, it is very important that you contact your local legal aid or child support office before you start falling behind in your child support payments. Should you have any additional questions, please call the State Child Support Hotline or visit your local county child support division.